You want to get all your medical treatment, your initial medical records, as well as prior medical and mental records as early as possible. And make a comparison with those medical records in terms of what was reported and what is in fact being alleged. So once a case is in litigation, there is a number of discovery tools that can be used to attempt to obtain additional information. And so as indicated earlier, in Massachusetts, we have an extremely limited discovery process. We do not have much in the manner of obtaining information other than by the manner in which we'll discuss. One of those mechanisms of discovery is a request for production of documents. So if there is specific information that we want and the employee is represented, a request for production of documents is sent to that attorney. It could be for tax records, tax returns, medical records, any type of information that you believe the employee retains that you need or is necessary. By filing that request of production of documents, there's statutory guidelines in which you can then request that that request production of documents be adhered to. And so if it's necessary to go into court for a motion to compel in order to obtain that medical or evidence or non-medical evidence, you've already established the request for production of documents, and you can then set forth to a judge the reason or the manner in why that's important. Now, given the limited discovery that is engaged in between in the workers' compensation system, there are, in the event that there's a third-party action, so there is a third-party action that is resulting from the work-related injury, there is the opportunity to contact that third-party attorney and obtain any information that may be generated from that discovery. So answers for interrogatories, have there been any deposition transcripts? And you can work closely with that third-party attorney in order to obtain any necessary information as well. For example, I have a case that legitimately has a third-party action involved. Our case has not yet reached a hearing level, which is where I would cross-examine the employee and the employee would testify. The opposing attorney tactically has been delaying that hearing because once that employee testifies or gets cross-examined, in the third-party action, that testimony can be used against him via whatever his deposition transcript may reveal. So my effort and goal is to obtain the deposition transcripts of the employee and any witnesses so that I have some form of negotiating tool or cross-examining tools to question or challenge the employee's credibility. And so that becomes somewhat difficult because although our interests are somewhat aligned, there is a concern that if the employee testifies and he testifies appropriately, then that third-party action does not have the legs it may have. So you're always trying to balance the pros and cons of your case with that of the third-party case, understanding that the third-party action will give you potential recovery. So we're right now in a situation where the judge wants us to try the case regardless of the third party, so that employee may, in fact, have to testify regardless of the status of that third-party action.